Hello, everyone, and welcome to our latest ALTA Insights webinar. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a real interesting presentation lined up to discuss joint ventures and the related state and federal regulations that govern these business relationships. This is definitely a hot topic, as we had about 750 people register for today's presentation. And as you probably know, ALTA has members on both sides of the fence when it comes to joint ventures. So it's definitely important to have conversations about the relevant laws and regulations, so you all can better understand compliance expectations. ALTA supports fair and appropriate enforcement of laws and regulations. At the same time, it's important for the laws to be fair to both consumers and businesses. We do want to note that while our speaker is an attorney, this presentation should not be considered legal advice, and we encourage you to seek out counsel if you are considering a business partnership. Today's webinar is being recorded. You'll get an email with a link to the recording tomorrow, and you can always access all of our webinar recordings at alta.org/webinars. That's alta.org/webinars. You can also download a PDF of the presentation from the handout section in the GoToWebinar window. If at any time you have a question, submit them in the questions box. We'll hold some time at the end for Q&A. I need to thank SoftPro for sponsoring today's webinar. And before introducing today's speaker, we have a short message from SoftPro.
Introducing SoftPro Sign, your one-stop solution to facilitate e-closings in SoftPro. With SoftPro Sign, all parties involved in a real estate transaction can securely sign and/or notarize documents online. You can easily send out documents for e-signatures from within SoftPro 360, saving you time and costs associated with a traditional paper closing. Your customers will receive an alert letting them know they have new documents to sign. Once signed, documents are automatically returned to your SoftPro 360 queue. For remote online notarization closings, your notary can meet virtually with the signer and perform a credential analysis to ensure a secure signing. E-signing and remote online notarization have never been easier or more secure. Learn more at www.softprocorp.com/sign.
Okay, well, thank you very much, SoftPro, for that message. All right. Let me make you the presenter. And now I'd like to introduce today's speaker. Joining us today, we have Jeff Ehrlich. Jeff is partner of the law firm McGuire Woods. He represents clients in the consumer finance space, providing advice and counseling to businesses that compete in markets governed by multiple state and federal agencies. Before joining McGuire Woods, Jeff served as Deputy Enforcement Director for the Consumer Financial Protection Bureau. And in that role, he managed investigations and litigation in the Bureau's 4 regional offices and headquarters. Jeff, welcome, and I'll turn the presentation over to you.
All right, thank you, Jeremy. Jeremy, I'm not sure I see where to share the screen again. It seemed like that went somewhere. Can you walk me through that maybe?
It should be the drop-down box, show screen. Do you not see that anymore?
Nope. Nope, there it is.
Okay.
Just came.
I own that. I didn't click a button.
No problem. Okay. So, Jeremy, can you see my presentation?
There we go. We're ready to rock and roll.
All right. Well, thank you, first of all, Jeremy, for the introduction and for having me today. As you said, I had previously worked at the Consumer Financial Protection Bureau for about 10 years before I came to McGuire Woods about 1.5 years ago. So the perspective that I'm bringing today is really that of a former regulator. I'll be fully transparent. When I got to the firm, I was hired by some title companies to help address what they viewed as a problem sham JVs in the markets in which they were competing. They asked me to help with them, attract the attention of regulators, and I've been working on that for a year. But nobody is paying me to do this presentation today. I'm just here sharing my own views. They're my views. I'm a lawyer, but I'm not giving you legal advice, as Jeremy said. Maybe someday we'll have an attorney-client relationship, but it's not going to be formed today. So I'm happy to share my thoughts as a former regulator. I understand there are different views on a lot of the things that I'm going to talk about today, and so you'll have to make up your own mind. But I hope that my perspective is helpful. So let's get started. I'm going to discuss frame the problem. The problem is the sham JVs, and I'd like to think that most people on this call are against sham JVs. There's not a lot of redeeming qualities, I don't think, to sham JVs, we might have different views on what is a sham JV. We'll talk about 3 laws. I'm going to try to do this in very simple terms, not try to make this too legalistic. But one question we'll explore is what effect some laws might have on RESPA compliant JVs. So with that said, we'll get started. Okay, so let me describe the problem as I see it. So in the last few years, maybe somehow this is tied to the pandemic, there's been a proliferation of in the real estate market of joint ventures between title companies and real estate agents. An existing title company will form a new title company, and for no charge at all, or for a steep discount, will offer real estate agents the opportunity to invest in the new title company as a joint venture. The real estate agents refer their customers to the joint venture for title services, but the fact is most of the work is performed by the parent title company that helped set up the JV, either on a contract basis or some other basis. The JV itself, the new title company, often is not well capitalized, doesn't have a lot of employees, doesn't do its own marketing, this is the situation that I described as a sham. It's not a real title company. It may be technically performing title services, but not in the way that all of you who run full-fledged title companies are doing. Because consumers don't shop, they're referred to the JV by their real estate agent. They're vulnerable. They're subject to being taken advantage of. They're often sold enhanced policies without being informed of alternatives. They're often not told about reissue rates on title policies, and so they end up paying more. And law-abiding title companies that don't engage in sham JVs, of course, lose volume of business. From my perspective, these sham JVs are harmful to consumers and to competition. It's the type of law that should be enforced, I hope that's something that folks can agree on. You all know about RESPA, but I'll just cover it very quickly. Of course, RESPA prohibits giving or accepting things of value for business referrals. There is an exception in RESPA for affiliated business arrangements that allow 2 types of businesses, a title company and a real estate agent, for example, to engage in an affiliated business arrangement together that then allows the compensation for referrals. It's an exception to the prohibition on kickbacks. There are 3 requirements for a lawful affiliated business arrangement in order to qualify for the exception under RESPA. The arrangement must be disclosed to the consumer before the referral. Consumers must not be required to use any particular provider, and the only thing of value that the referring party may receive is a return on their investment that is commensurate with their ownership share. So if the real estate agent owns 10% of the JV, they can get 10% of the profits that the JV distributes. If you follow those 3 requirements, then you've got a lawful affiliated business arrangement and you're RESPA compliant, and you should be good to go, at least with respect to federal law and this law. There are, of course, situations where people think that they're complying with these requirements and they have a lawful affiliated business arrangement, but really they don't. And that situation arises when the referring party receives a thing of value different from their ownership share in the JV. So here's how that violation would look. If a real estate agent is being allowed to invest in the JV at a steep discount that is not commensurate with the capitalization of the JV, then they are receiving a thing of value that's in addition to the one that's permitted, right? They're allowed to get a distribution of ownership of profits according to their ownership, but they're not allowed to get another thing of value. And Regulation X, which is the implementing regulation for RESPA, defines thing of value to include discounts, the opportunity to participate in a money-making program, and increased equity in a parent or subsidiary entity. So when agents get to invest in a JV by contributing little capital in exchange for a significant return, they're receiving a thing of value that is different from what is permitted under the exception for affiliated business arrangements, then it's no longer entitled. They're no longer entitled to the protection, the safe harbor for affiliated business arrangements, and it's just a violation of RESPA's prohibition on kickbacks. So that'd be a RESPA violation. I'm going to talk a little bit about law now because I've talked about a federal law, RESPA. I think it's important to talk about state laws, as I'm sure many of you know. States are all over on this. Many state laws have laws that are just like RESPA. They prohibit kickbacks, and they have an exception for many things, including affiliated business arrangements. There are other state laws that prohibit kickbacks and have an additional test for whether an entity is an affiliated business arrangement. They might employ the HUD factors, the 10 factors that HUD released decades ago, that are still at play a little bit under RESPA, but not in the Sixth Circuit. At least we know that. There's state laws are in play, and RESPA contemplates this, right? This is a provision of RESPA, you can read it for yourself, but what it means is that states can place greater restrictions on settlement services than RESPA does. So in addition to the types of laws that I just described that just sort of mirror RESPA or that impose an additional test for affiliated business arrangements, there are some states that, like RESPA, prohibit kickbacks, but they don't have an exception at all for affiliated business arrangements. And so those state laws are certainly more restrictive than RESPA. They offer greater protection to the consumer than RESPA. And so RESPA contemplates that these laws will apply parallel to RESPA. And so if you look at the statute, it says RESPA does not exempt any person from complying with the laws of any state, except to the extent that the laws are inconsistent with any provision of this chapter. Then the Bureau, who's the agency responsible for declaring whether a provision is inconsistent with this chapter, the Bureau is authorized to determine whether such inconsistencies exist, and the Bureau may not determine that any state law is inconsistent if it gives greater protection to the consumer. So a law that prohibits kickbacks altogether and doesn't create this exception is going to give greater protection to the consumer, and so those state laws, in my view, are valid, and anybody setting up a joint venture is going to have to be aware of the state laws that might govern it as well, in addition to RESPA. So let's take a look at a couple of these state laws. This one is, I think, the simplest, certainly the shortest of the laws that I'm aware of. The DC Code, Section 5031.15, it bars giving or receiving, directly or indirectly, any consideration for the referral of title business or escrow or other service provided by a title insurer. Okay, it's a straightforward prohibition on kickbacks. It would prohibit a JV title company from sharing profits with owners who refer business to the JV. Okay, that's how I read it. I know there may be people who disagree, but I think this statute is pretty clear. And so it's possible in DC to set up a JV that complies with RESPA. you do everything. You give disclosures at the time of referral. You don't require use, and in fact, the JV is perfectly capitalized. The real estate agents invest substantial amounts that are commensurate with the return, a reasonable return, and so it meets the requirements for an affiliated business arrangement. It's not a sham. I think that JV that I just described in the District of Columbia is likely violating this code provision. And so that's just something that you should be aware of if you're trying to set up a JV in the District of Columbia. By the way, I've heard like all kinds of arguments about how this isn't valid. And my favorite one was that DC is not a state and RESPA only allows for states to enact laws that protect consumers more. That's not going to fly. RESPA and Reg X both define state to include the District of Columbia. So there's that. There are a lot of other arguments that I've heard, and I've not been persuaded by any of them. But again, it's just my view. Arizona revised statute section 2015-85. The statute's a lot wordier. I cut out some of the words, but it does the same thing in my view as DC's code provision, or at least arguably it does. A regulator could certainly conclude that. This statute bars giving or receiving, directly or indirectly, any consideration or compensation for a title insurance business. Again, I think this statute could be fairly read to prohibit a JV title company from sharing profits with owners who refer business to the JV. And again, I think it could be applied to a RESPA compliant JV. There are other states that have laws like this, New York, Ohio. There may be others that I'm not aware of. Again, I'm not here to give legal advice. I'm just telling you that some of these states have statutes like this. They exist, and you should be aware of them if you're looking to set up or if you're operating a JV in one of these states. And again, there may be ways to set up a JV that complies with one of these state laws. Like, let's go back just to a simpler one. We'll look at the DC law again. It doesn't prohibit a real estate agent from being in a joint venture with a title company. All it prohibits is paying, giving directly or indirectly consideration for the referral of title business. So an agent could be a member of a JV and not refer any customers to that JV. Okay, that's probably not going to violate this provision. An agent could refer customers but not take any distributions from the JV. Okay, again, extremely unlikely. Both of those examples would defeat the whole point. The whole point of these JVs and affiliated business arrangements is really to compensate people for referrals. So I don't think that if these laws apply the way that I suggest and that others might read them to apply, I don't think they allow for JVs in those jurisdictions. Now, that's the bad news. As I said, I think these state laws would apply not just to sham JVs, but also to RESPA compliant JVs. And I can't tell you how states might use these laws. I can tell you they haven't used them much. I couldn't find any cases where really Arizona or DC had ever applied these laws, but they're on the books, and presumably there are some people who are trying to abide by them. I think there's a feeling that the CFPB in the states are more active in this space at the moment. I wouldn't be surprised if the CFPB were to bring another RESPA case before the year's done, and I expect at least one state will as well. I've heard, I'm sure many of you have as well, that there are some states that have been sending out subpoenas and sending out draft consent orders and trying to get, do some enforcement work in this space. But I think there'll be more. And it's hard to predict how other states, particularly states that have these laws available to them, will use them. What I will tell you is how I would have used them if I were still at the CFPB in enforcement, where I was for 10 years, and how I think states should use these state laws. To me, any law enforcement officer has to make decisions about priorities, and to me, the sham JVs are causing the greatest harm, and certainly causing greater harm than a RESPA compliant JV. So if I were state AG and I had one of these laws at my disposal, I would use it. I would only use it against sham JVs. And if I could find a sham JV that was worth bringing a case against, a RESPA case against, I would bring a RESPA claim, and I would bring a claim under my state law, asserting as an alternative basis that the JV is unlawful because under my law in DC or Arizona or one of these other states, it's simply unlawful to compensate members of the JV based on their referral of title business. I would not use these statutes as like standalone swords to go after all JVs, but you know, they're written, I think, in a way that might allow for that. So it's something to be aware of. Now my favorite part of the discussion, perhaps the most controversial part of my presentation today. I want to talk about the Consumer Financial Protection Act, which is the law that I have the most experience with from my time at the CFPB. I brought 106 enforcement actions. That's more than anyone in the history of the Bureau. Probably about 3/4 of them were CFPA cases, enforcing that statute's prohibitions on unfair, deceptive, and abusive acts and practices. And I think that there is a space for the CFPA in the problem that we've been discussing. And I think it applies mostly to real estate agents. And I understand my audience, and I will explain at the end why title companies should worry about real estate agents, perhaps potentially violating the CFPA. So bear with me while I walk you through this. First thing you should know is that ordinarily the CFPA's prohibitions on abusive conduct, they don't apply to real estate agents. Okay, the CFPA applies to defined persons, covered persons, and service providers. Covered persons are persons who offer consumer financial products or services, including title services. Okay, so title companies are covered persons, but real estate agents are not ordinarily covered persons. They're not offering a consumer financial product or service. They're doing real estate. And then another reason is that there's actually a specific exemption in the CFPA for real estate agents. Section 1027B of the Act prohibits the Bureau from exercising any rulemaking, supervisory, enforcement, or other authority with respect to a real estate agent, unless the real estate agent is engaged in activity of offering or providing a consumer financial product or service. So if the real estate agent were also set up as a mortgage broker, then yeah, of course the Bureau would have authority. But if they're just doing real estate work, the Bureau really doesn't have any authority over real estate agents. So many real estate agents don't really think about the Bureau much. Of course, RESPA applies to them, but they're not thinking about it in terms of being regulated by the CFPB. So ordinarily they're not covered, but when they engage, when they participate in JVs, they kind of insert themselves into the mix. The CFPA applies, and that's because the joint ventures themselves are covered persons because they offer title services. As I mentioned, offering title services is the kind of thing that if you do, it makes you a covered person. So this new company that's been created, the JV, it is a covered person itself. And then the statute, the CFPA, says that members of a JV who participate in its operations, materially participate, are called related persons and are deemed covered persons. So once you're deemed a covered person, then all of the laws that apply to covered persons will apply to you as well. So a real estate agent who materially participates in the affairs of the JV by referring their customers to it, they're gonna subject themselves to being related persons and therefore covered persons. And now the prohibition on abusive conduct applies to them like it does all other covered persons. Okay, what is abusive conduct? In a recent policy statement on abusive conduct, the Bureau is now just interpreting the statute. It's not entitled to any more weight than the language in the statute itself, but at least the Bureau gives us an idea how it views this. And what it said is that sometimes people are in a position in which they have a reasonable expectation that an entity will act in their interest to make decisions for them or to advise them on how to make a decision. Where people reasonably expect that a covered entity will make decisions or provide advice in the person's interest, there's a potential for betrayal or exploitation of the person's trust. Therefore, Congress prohibited taking unreasonable advantage of a reasonable consumer reliance. Okay, and so that's what the statute prohibits. It's an abusive practice. It's a violation of the CFPA to take unreasonable advantage of the reasonable reliance by the consumer on a covered person to act in the interest of the consumer. And so there's some, we have to break this down because there are places where this could break down. In order for there to be a claim under the CFPA, the consumer's reliance on the covered person has to be reasonable. Okay, it can't be unreasonable. I think real estate agents are in a very vulnerable position here because this is going to be very fact intensive. It's going to depend on the particular situation, but often real estate agents work with consumers for weeks or months, helping them find a home, and then they advise them on all kinds of things, how much to put down, where do you find an inspector, what title company should you use, all sorts of the decisions that go around that very significant decision in a person's life, right? Buying a home is something that people, might not do in their lives at all. Maybe they just do a couple of times in their lives. It's a big deal. And I think consumers quite reasonably, start to feel that they're getting advice from this real estate agent. And if the real estate agent is a covered person, I think it's reasonable for consumers to believe that they're giving them advice that's in the consumer's interest, not the real estate agent's interest. I think, we're talking today about title companies, but of course there are these JVs between mortgage brokers and real estate agents as well. And, I think in any of those situations where a real estate agent refers a consumer to either a mortgage JV or a title JV, I think it's reasonable for the consumer to believe that the real estate agent is doing that in the consumer's interest, not that they have a financial stake in the entity to which they're referring the consumer, such that they're working in their interest, okay? And so I think that in those situations where it's reasonable, and then it's not always gonna be the case, but where a consumer reasonably relies on the real estate agent to refer the consumer to a mortgage JV or a title company JV, and in fact, the reason for the referral is that the real estate agent is profiting from the referral, I think that's a potentially abusive act under the CFPA. One place where this could break down is, you might say, well, what about the disclosure, right? The real estate agent is disclosing to the consumer that they have this financial interest. So we do need to address that in a minute. And I do think that comes into play. I do think, particularly with this first potential violation, the bias steering, as I said, and the Bureau talked about this in the same policy statement that I mentioned before. It says, in situations where a buyer might ask the agent to recommend a mortgage company or a title company, the Bureau said the entity, so here the real estate agent, acting as an intermediary, can function as a broker or other trusted source for the person in using and selecting, negotiating for, otherwise facilitating the procurement of a consumer financial product or service, the mortgage or the title services. In the Bureau's views, and again, this is language from the Bureau statement, so it at least tells us what the Bureau thinks. People should be able to rely on the entity to do so in a manner that is free of manipulation. And those that engage in certain forms of steering or self-dealing may be taking unreasonable advantage of the consumer's reasonable reliance. So, so that's the theory, right? That the real estate agent who refers the customer to the agent's own JV risks violating this prohibition because they are acting in their own interest, not in the consumer's interest. So that's that theory. The second theory is a little bit different, and that has to do with the neutral role that a closing agent plays. And of course, this is different in different jurisdictions. The role that the title company plays in the closing. In most jurisdictions, a title agent is a third-party neutral with fiduciary obligations to both the seller and the buyer. Okay, and indeed, as the Arizona Association of Realtors recently observed, a title company is a neutral third party employed to ensure the title to the home and the title insurance policies to the buyer and the mortgage lender. Title company's duties include researching the history of the property to identify potential problems, claims, or discrepancies that may interrupt the transaction. Because the title company is charged with formally transferring ownership from the seller to the buyer, it is critical that they serve in an impartial manner. When the title company is a joint venture, so when the title company is serving in this role as escrow agent or closing agent, and it's a joint venture between the parent title company and the buyer's real estate agent, it lacks the disinterestedness that the law requires. And it's potentially to the detriment of the seller, who, like the buyer, is a consumer, and the seller is entitled to the CFPA's protections. So the seller is entitled to the escrow agent, closing agent, title company, remaining neutral, resolving disputes in a neutral way. But when that entity is partly owned, literally by the agent to one of the parties to the transaction, that neutrality is not present. And that's where the seller, I think, could be being taken advantage of in an unlawful way. The disclosure, particularly, well, it might apply to both of these. My thought on the disclosure is that it's got to be a pretty good disclosure in order to undo the consumer's reasonable reliance on the real estate agent to act in the consumer's interest. And I think it's unlikely that most disclosures would dissuade the Bureau from enforcing the CFPA in this way. It's particularly true when the purported disclosure is made, as it often is, after the referral. For example, when it is buried among dozens of pages that the parties sign when ratifying the purchase agreement, in language that is really, confusing to the average person. And in fact, the Bureau has brought abusiveness claims in prior cases, despite there being disclosures that consumers had little time to review and were unlikely to understand. I brought cases like that. So, and the Bureau's policy statement, the one that I've been discussing, does talk about this. It cites back to a Treasury Department report that observed that consumers may retain faith in an intermediary, that an intermediary is working for them and placing their interest above his or her own, even if the conflict of interest is disclosed. So the Bureau has recognized that these disclosures may not be enough to negate the reasonable reliance that a consumer has on a conflicted intermediary, right? And in those situations, the Bureau seems to believe, as it said in the policy statement, that consumers may reasonably but mistakenly rely on advice from conflicted intermediaries, right? So, if you give the disclosure, it's not, you could make the case that it's wrong for the consumer to continue to rely. They've just been handed a piece of paper that says, hey, I own an interest in the title JV that I'm referring you to. Okay, so it's wrong for the consumer to continue to rely on that person to give advice that's in the consumer's interest, but it still may be reasonable. And again, it's really going to depend on the facts and the circumstances, the relationship between the real estate agent and the consumer, and the nature of the disclosure, the timing of the disclosure, and how understandable it is to the average consumer. But I do think it's a risk, and it's a risk that real estate agents in particular should be concerned about. One argument I've heard about this is, people have said, how can it be illegal? How can this be illegal under the Consumer Financial Protection Act when it's legal under RESPA, right? Joint ventures, if done lawfully, like I've said, if they're set up in the right way with the required disclosure at the right time, not required use, the only thing of value the referring party receives is their share of the profits. Hey, that's a lawful affiliated business arrangement, and the whole situation I just described involving the real estate agent, that might not be a RESPA violation. And so people say, well, it's lawful under RESPA, how could it be illegal under the CFPA? And again, you don't have to take my word for it. I don't know the answer to that question. I think there are good arguments to be made for how the CFPA could apply and fill this space where RESPA doesn't exactly reach. But what you should be more concerned about is the CFPB's view on this, because the CFPB has been very clear on this. Their exam manual says that a transaction that is in technical compliance with other federal or state laws may nevertheless violate the prohibition on UDAPs. That's the prohibition on abusive acts or practices. And by the way, the CFPB is not the only agency that takes, the CFPB is crazy in a lot of ways, but they're not alone in this view. The FDIC has the exact same approach. The FDIC tells its covered entities, hey, you might be in compliance with another federal law or with a state law, but you still could be committing an unfair or deceptive practice under the FTC Act, which we enforce. And in its recent circular on overdraft fees, the Bureau spoke to this again. It asked and answered in the affirmative this question: can the assessment of overdraft fees constitute an unfair act or practice under the CFPA, even if the entity complies with the Truth in Lending Act and Regulation Z and the Electronic Fund Transfer Act and Regulation E? The Bureau said yes. So you can comply with these other laws and still violate the CFPA. And I think that's the approach that the Bureau could take here. They could say, yeah, okay, real estate agent, member of the JV, yeah, you complied with RESPA, but you're meeting the elements of this offense. You're still taking unreasonable advantage of a consumer's reasonable reliance on you, a covered person, to act in the consumer's interest. And I think the Bureau could take that approach. And by the way, state AGs also enforce this law, and I think a state AG could take that approach. So while real estate agents might be able to form affiliated business arrangements that allow them to receive kickbacks without violating RESPA, doing so does not necessarily protect them from enforcement by the CFPB or a state AG of this law, which is a different law. But I will also say this: like with the state laws, I don't think I'm not sure that the Bureau would bring a standalone CFPA case like this, and I would hope that a state wouldn't either. I think they should all prioritize the sham JVs, which are, to me, are causing the biggest problem. But I think if the CFPB were to find the right case, they would bring a RESPA claim against a sham JV, and they would bring a CFPA claim against a sham JV and the members of the JV who have participated in it, the real estate agents, under the theory that I've just explained. Now, the question, of course, why should a title company care that a real estate agent may be violating the CFPA? And the reason is that you have every reason to care. The CFPA, the same statute, makes it unlawful to provide to knowingly or recklessly provide substantial assistance to a covered person in violation of the provisions of Section 5531. The provider of such substantial assistance shall be deemed to be in violation of that section to the same extent as the person to whom such assistance is provided. So let me break that down for you. Essentially what it's saying is that any person, by the way, this is any person who knowingly or recklessly provides substantial assistance to a covered person, so in this case it would be the real estate agent, in violation of the provisions of Section 5531. 5531 is the prohibition on includes the prohibition on abusive conduct. Then that person is just as liable. So if you are a person, which of course includes title companies, the other members of the JV, if you're providing substantial assistance to the real estate agent who's taking unreasonable advantage of the consumer's reasonable reliance on the real estate agent to act in the consumer's interest, then you are just as liable as the real estate agent. And that's why I think title companies should be wary of this and at least aware of this problem as well. So I'm at the end of my presentation. I'm happy to take questions. Jeremy, do you want to reclaim the floor for me, or anything I need to do for that?
Yeah, definitely, Jeff. Great insight on what title agents, the folks on today's webinar should be thinking about if they're considering entering into a business relationship with an agent, or if they're currently in one. We are going to hold some time for Q&A, and Jeff, they are coming in like hotcakes. So
I'm sure.
We've got 15. We'll take 15, 20 minutes. We'll see what shakes out. One question, I actually had it too, and Beverly submitted it, is on the surface, how can you tell that a joint venture is a sham?
Yeah, well, In some places, that's easier than others. In some jurisdictions, they still apply the HUD 10-factor test, and so there's sort of 10 factors that you look at and sort of take the totality of the circumstances and answer the question, is this a legitimate business? And they include things like, does the entity have its own employees? Does the entity market for business other than the business that's being referred to it by its members? There are a few others. So even in the states where the HUD factors are no longer considered part of the law under RESPA, I still think that that's really the prudent place to look. Work with your counsel, look at those factors, and make sure that you're setting up a JV that's not a sham. That's the first step. If you can set up a legitimate JV that's properly capitalized and runs like a normal business, and it just so happens to be owned by its investors include real estate agents who are making referrals to it and receiving distributions from it, I think you're RESPA compliant. So, you're at least going to, solve that problem. And I think that's the biggest problem. There is the other part of that is, of course, it has to be properly capitalized. The investment that the real estate agents are making, has to be appropriate for the type of return that they're expecting. And there are people who can help you measure those questions as well. But I think the closer you get to setting up a non-sham, a lawful affiliated business arrangement that's properly capitalized and where the investment is high enough to make this a reasonable arrangement, the more it defeats the purpose of these. Because if the purpose is to pay kickbacks to real estate agents for their referrals, it doesn't work as well when you end up having to pay them lots and lots of money for that. So that's my view on the value of these JVs if they're done properly. But I do recognize that under RESPA, there could be lawful JVs set up.
Yeah, a lot of the statutes you cite, are how they impact the relationship if the joint venture is with a real estate agent. We've had a few questions come in about attorney states where an attorney owns the title company or has a joint venture. The question is, are you saying the attorney / title company and I guess it is real estate brokerage. The real estate brokerage could both put in $10,000 each and do a disclosure, then both can share equally in the profits, although the law firm is using all of its resources to the work and the brokerage is doing nothing. Now that I'm reading through that, is that your analysis would be considered a sham?
I don't know. Yeah, Jeremy, I can't. That's like a little too specific for me to answer.
Okay.
I don't know. How that would turn out under RESPA. I do think that there are some of these state laws where even an arrangement like that, maybe not that one in particular because you're talking about a broker and lawyers, but I do think a lot of arrangements that involve the referral of title business between all different sorts of players could get caught up in these state laws. And I'm not sure. I'll confess, I'm not sure that was the intent of these state laws. I suspect that it wasn't, but that's how they're written, and I think they can be enforced that way. I think they can be interpreted that way. If I were advising a client, I'd be very careful about operating in a state with one of these laws, because I think that you could get caught up in it.
You talk about providing core functions. Is there a clear cut and dry explanation on what should be required from a joint venture
in order to not be a sham?
Yeah,
I think you could go back and look at the HUD guidance where they initially discussed the factors. I think that's still relevant to a large extent.
Yeah.
So that's to me that's a resource. I would look at that if I were, and I believe that the attorneys that I know that help entities set up JVs and that audit them to make sure that they're complying with RESPA, they still look to the HUD factors and that statement to inform their advice.
Okay. Question from Rich when you were talking about the DC and the Arizona statutes and having specific language that you believe prohibits these. He asked, do states also have an ABA exceptions? And this might be too specific, like New York Reg 208. I don't know what that says. Which demonstrates a clear pathway for joint venture relationships.
Yeah. So I think what the question's getting at is that there are some confusing provisions in some states, and New York is one of them, because New York has a statute that is very similar to Arizona's and DC's, but there are some other like laws that are seem to allow for certain arrangements. And I think at the end of the day, you're gonna have to do some analysis to determine whether those laws conflict, and if they do, how can you reconcile them? And if you can't, then you have to go into principles of statutory construction to try to figure out which law applies and which doesn't. But I've had these discussions with some lawyers, and they've pointed me to laws, particularly in Arizona. Someone was like, oh, take a look at this law, it specifically allows this. And I looked at it and I was like, no, it doesn't. In order for you've got to find a statute, I think, that expressly conflicts, with one that says that this is illegal. And then I'll be willing to have a conversation with you about what to do, with that state law. But I think it's a lot of wishful thinking on the part of some of these lawyers. And by the way, like there may be regulators. I've been told that some state regulators where the law expressly prohibits giving any consideration to anyone who makes a referral of title business, but some other regulator puts on its website information that suggests that that's legal. So that's like tricky. It definitely brings in principles of fairness and due process. And is it fair to prosecute someone who might have relied on on the website that says something contrary to what the statute actually says? Those are certainly issues that would have to be dealt with. But I'll say this: at the end of the day, the legislatures make the laws, not some unelected regulator, and not someone who puts something up on a website. So you're going to have to deal with that, and we've seen that. My friends who've brought the Townstone case, successfully made that argument that only Congress could say what that a COA reach, who a COA reaches applicants, right? And the Federal Reserve and now the CFPB can't have a regulation where they expand on that definition. Well, the same thing applies here. The DC Council passes the law, the Arizona legislature passes the law, and if some regulator, makes some different statement about it and puts it on a website, I think, there might be prudential reasons not to enforce that law, or, perhaps to enforce it, but not seek penalties, for its violation, just out of fairness. But it doesn't negate the law, right? Like, some state regulator can't just like negate a state statute that was lawfully enacted. So those are my views on that.
All right, a lot of questions coming in, so apologize, and they're kind of all over. I'm trying to look at them and organize
no problem.
In certain buckets, but the way this system works, it jumps around. An interesting question from James, and we're talking about JV when it's with an agent, but his question is, does it change the analysis when the JV is with a brokerage rather than an individual agent?
Maybe. I mean, I think what you have to look at the end of the day is who's making the referral to the JV, and that is the person who can only the person who's receiving distributions from the JV is the owner, or the owners of it, right? And so the question is are those owners making referrals? And so, again, a little bit beyond the scope of what I'm presenting on today, and I'm not sure I want to get into specific cases, but that's what you want to look at, is like the prohibition is on the person who the members of the JV receiving something of value in addition to the distributions of profits. And if they are not, then you've got a lawful affiliated business arrangement, no RESPA violation. But if they are, then I think you're not an affiliated business arrangement, and you run into the prohibition on kickbacks. But I think I'm going to pass on the question. I think it's a little too specific for me to answer.
Okay. Could you review you're talking about disclosure about, affiliation, joint venture. When should the realtor disclose, and when should a title company disclose? And
Yeah, so yeah,
and have
everybody
sign, and who should sign?
Yeah, I mean, I'll skip some of the details, but the person making the referral, if they're making a referral to an affiliated business arrangement, they have to disclose that at the time of the referral, when it's meaningful, in other words, so that the person knows before they're sent to the JV, they understand that there's a conflict and they have an opportunity to look elsewhere for those services. If the disclosure happens after the referral or really late in the process, it's not a meaningful disclosure because the ship has sailed. And so that's why, I mean, this isn't me, that the statute requires that the disclosure be made at the time of before or at the time of referral. And I believe the CFPB's website, they have model disclosures that are probably safest to use. But I think you should ask yourself, like, look at it, read it. Is this something that the average consumer is going to understand? Is it going to be meaningful to them? And that's, I think you really, like, that's the heart of it, right? Like the whole point is, look, there's a conflict here. We can get past it, but in order to get past it, we got to deal with it. And you deal with it by giving a timely and meaningful disclosure. And the statute and the reg spells, what the requirements for that are.
Okay. Question from Rachel. She is interested to know if it's a violation if an attorney owns a law office and a title company, and as an attorney steers business to their title company and only prepares the real estate contracts that name his company.
Steers, I don't know. I would be, I'd have to, I can't answer like these questions about specific facts. Is this a violation? But I would be very, very nervous about that one. I mean, I would look at that very carefully. And by the way, the CFPA does also provides an exception, just like for real estate agents, it does for attorneys as well. But it's only when the attorney is acting in the context of an attorney, providing legal services in the context of an attorney-client relationship. And I think that this kind of thing would be outside the scope of that. So I think attorneys have been held liable under the CFPA, and I think they could be under these situations if the facts are right. I don't want to, it's just too hard for me to kind of give a verdict based on a couple of sentences, and I think it'd be hazardous to do so. So I'll take a pass.
Okay. You mentioned the CFPA, and so a question whether the CFPA is applied the same way to wholly owned subsidiaries as it is to JVs. For example, a mortgage company referring title business to a wholly owned title subsidiary.
Just repeat that last part again.
A mortgage company referring title business to a wholly owned title subsidiary. So would the CFPA be applied the same?
It might. I mean, it's going to turn again. It's going to be the same legal analysis. Like, does the consumer involved have a reasonable expectation that the person making the referral, and in this example, those are going to be covered persons. You don't have to deal with the whole like related person, because the entities you mentioned are covered persons. So the question is just going to be, is it reasonable for the consumer to believe that the person making the referral is acting in the consumer's best interest? If that's unreasonable, then you're not going to have a claim. But if that's reasonable and the person making the referral is acting, in their own interest, then I think that could be a claim. It's very fact dependent. Like, it's really, I mean, these cases are going to turn on. You're going to, if this case arises, it's going to be a disgruntled customer, right? Who's going to come in and tell, the investigators at the CFPB about their experience with the agent and working with the agent very closely for months. And the agent gave all kinds of good advice, and the agent gave this advice as well. And the consumer relied on it and believed that the agent was acting in the consumer's interest. But in fact, weeks later, the consumer learned that the agent was acting in his or her own interest. That would be the case. It's really going to depend on the facts. But if, for title companies who are working with real estate agents, you got to be careful. Like, who are you working with? And I think you're going to want to vet the people that you're working with, and not necessarily take all comers. You're going to want to take all comers who take compliance seriously and understand their rights and obligations under the law. So again, I'm not telling you that this can't be done legally. I'm just saying that you should be careful, because it can also be done illegally.
Jeff, do you have any specific examples of state regulators that have taken this more restrictive interpretive approach to joint ventures?
No, I mean, I've just heard, I was at an industry partners conference in Arizona last week, and I hear stories about state regulators and then state attorneys general. I was at an ABA consumer finance conference and met with a state AG who is, I think, pretty active in this space, not in one of the states that we talked about today, so another state. I haven't seen anything public that I could point anyone to, but I've heard from reliable people that their clients have received subpoenas, and I believe that they're operating under this more aggressive theory.
Question from Timothy, and I don't know if you want to provide some insight. His question is, why does the enforcement action always seem to be against the title agent and not against the real estate broker or agent?
Yeah, that's a great question. I think part of it has to do with the exception for real estate agents. Like, the Bureau has to navigate around that to be able to get the real estate agents. But my view has always been that if the Bureau wanted to first of all, one thing the Bureau could do, and I think there'd be a lot of agreement on this, is issue a bulletin, right? Like, tell people that we view this as illegal, and I think that would go a long way toward curbing this conduct. Instead, you got people like me out here coming up with our own theories and telling you what might happen. Although I do think there's a basis for what I'm telling you, obviously. But I do think that the Bureau, that the state AGs, that the other regulators in this space, if they issued a bulletin, it would go a long way to sort of clearing this area, clarifying this area. So there's that. But the other thing that one of these agencies could do is sue a real estate agent. Sue a title company and sue a real estate agent. And I think if they wanted to get at this problem, they'd be hitting the demand side and the supply side, I wouldn't be surprised if someone does include a real estate agent in one of these enforcement actions before the end of the year.
All right. A question, arrangement with a little bit of a different flavor, marketing service agreements.
Yeah.
Between real estate agents and title companies. Are you seeing the CFPB looking at these as well?
Yeah, I think so. Yeah, I mean, I think the CFPB hadn't, before the case that they brought earlier this year, they hadn't really been active in this space. But I think, this is part of sort of a ramp up overall by the CFPB. They're hiring a lot more enforcement attorneys. I think they're going to be a lot more active in a lot of areas where they haven't been in the past. I think marketing servicing agreements and affiliated business arrangements are two areas that they're going to poke a little bit to try to get a handle on what they view as illegal kickbacks in the industry.
All right. Well, we are at the top of the hour, Jeff. One more quick question, if you don't mind. Otherwise, he does have a QR code, last slide, if you want to reach out and connect with Jeff and and pose your question to him or talk about joint ventures and their legality at a later date. But what is the procedure to report a sham JV at the state level?
To report one? You want to tattle on your competitors? Well, if you're willing to be upfront about it, you can just write a letter. Write a letter to the AG or to the regulator responsible for enforcing RESPA in the state. And sometimes people have evidence that they share. And a lot of these cases, even at the CFPB, during my 10 years at the CFPB, cases often arose through, you know, if not whistleblowers from within the company that might be violating the law, from competitors. You know, competitors are good sources of information. Of course, you know, any regulator is going to be very careful about information that is obtained from a market participant because, you know, it's obvious, right? They're complaining about their competitors, and so, you know, I don't think any regulator is going to rely on information that's derived solely from a market participant. But I do think that that is often a starting point for investigations. You know, I've seen that for a long time, and you know, I think that's what's happening here as well.
Okay, all right. Thanks, Jeff. Thanks for taking some time and offering, you know, your thoughts on what these, you know, regulations mean to you and how, you know, title companies should approach these and at the federal level and the state level. As a reminder, if you missed parts of today's webinar or think, you know, others in your office would benefit from listening, a recording will be available at alta.org/webinars, and you'll also get an email tomorrow with a link to the recording. Need to thank SoftPro once again for sponsoring today's webinar, and you know, that brings us to the conclusion of today's presentation. Jeff, thanks again for your analysis and view on joint ventures.
Thank you.
All right, hopefully it gives attendees some good food for thought. Take care, everyone.